live on YouTube.
Morning. Good morning.
Good morning.
Okay, so good morning. Hi, Mr. Razavi. Are you ready to get started, or would you like a breakout room with your client?
If the judge is ready, we're ready. If we have some time, I'll take a brief breakout room, but we talked yesterday.
Okay, so let me check with the judge and I'll let you know. Hang on. Mr. Razavi, he needs just a couple minutes, so we'll put you in a breakout room real quick.
Okay, thank you.
Thank you. And I'm assuming the person on the iPhone is your client.
Yes, Mr. Herman there.
Okay, there you are.
Jake, we're going to click join the breakout room. You and I will have a private room.
Oh, well, hello there.
Good morning.
Good morning.
How are you this fine morning?
You know, just fine.
Good.
You know, I don't know. It's Thursday.
Yep.
How about yourself?
Yeah, just
Okay.
I'm glad to be here.
Yeah. Yep.
It's got a full tank of life on it today.
Not a lot. It's the biggest docket we've had all week, to be honest.
Yeah,
Mhm.
4 prelims scheduled for today.
1, 2, 3, 4. Yeah. Well, Vincent Kelly is. Oh yeah, he's one of them. He's got bench one with that. Okay. Yeah, I mean, honestly, 1, 2 of them, 3 of them, all of them could possibly go. Oh well, no, that's not true. We see in counselor doesn't look like they have counsel. So let me look those up. 21, 5, 3, 8, 2. Oh, my eyes are just burning today. Oh, Miss Conlon was. What is that?
I just got that from the eye doctor yesterday.
And that's supposed to help
That helps
for burning and
for burning.
really? Can I use it?
Absolutely.
I won't touch
It's
my eye.
brand new. I haven't even touched it.
Well,
I
I
haven't
won't
even-
put it in. I won't touch my eye. Hang on. Huh, interesting. Let's see how it does. is.
Says it might tingle just a bit
Oh,
when you
yeah.
first put it in,
It
but
is. Is that a prescription?
no.
Oh, I need to write it down in case it works. Sustain what though?
Sustain Complete is what it's called.
Okay.
Lubricant eye drops. Optimal dry eye relief.
Do you have dry eyes too, obviously?
Yeah.
I have the worst. Oh,
My left eye, I get,
that does feel pretty good right now.
it's not it was an infection. I had an infection in it 2 years ago. It was really bad.
Well, and when you have dry eyes and you get an infection, it's horrible because the medicines make it worse.
Yeah, right now I'm doing steroid drops in it
Oh,
and have to take a cyclovir.
oh, you're
Because it's a
kidding.
viral infection.
Whoa. Did you have like a sore in your eye? Oh, that's really bad.
It's
Wow.
on my cornea.
Oh my goodness.
I've been battling that for, I don't know, the past 2 years.
Holy cow.
Good morning, sir.
They're not back yet. Sure they will be shortly. And these allergies and my nose just keeps running and I don't take allergy medicine. I don't like the effects of it. I don't like getting that. When I take it, I get all dried up and
My wife has allergies really bad.
who does?
My wife.
Mine aren't super bad. They just flare up every once in a while and. Okay, ready, Mr. Razaby?
Yes, thank you.
Oh, you're welcome. So far, that does feel pretty darn good. By the way. Thank you. We're ready, Judge, and the defendant's coming in right over.
All right, good morning. This is People versus Jacob Herman, file 215055SM. Mr. Razaby is here on the defendant's behalf, and Ms. Wilson is here from the prosecutor's office. This is the date for sentencing on the defendant's conviction of assault and battery. And Mr. Razaby, have you had an opportunity to go over the pre-sentence report with your client?
Yes, we had a chance to go over the pre-sentence report as well as the substance abuse assessment and recommendations. We also received the victim's impact statement, and we are ready to proceed with sentencing.
Okay, so what would you like to say then on behalf of your client?
Well, Your Honor, I would indicate that my client does acknowledge that he should not be consuming alcohol. While he is 22 years old, at his young age, it hasn't brought him anything but problems. I think that he was open and honest in the assessment regarding his alcohol use. I believe I read in the assessment that he began AA or attempted AA at the age of 17. So this is someone who has certainly been contemplating the role of alcohol in his life. This event is the first time that there was any indication of violence or anything like that. And I'm pretty confident that that was certainly fueled by his alcohol consumption. All my dealings with Jacob have been respectful and courteous, and he seems like a hardworking young man. I understand that he works for his father doing construction labor work. So he does have a good future ahead of him, and he does seem to understand that alcohol is not helping him in any fashion. So he is motivated to stay sober. Regarding the delay of sentence, I know that he's appreciative of that. He understands that this is a big opportunity. He certainly does not want an assaultive crime on his record. I would ask that the court not impose the recommended 7 days in jail. He has served a day already, and there will be conditions that he's going to obviously have to comply with. And if he fails to comply, then the court has of course, the ability to incarcerate him up to 93 days. So at this time, I would ask that the court not impose any additional jail time. I did see the restitution request. My client understands that he is going to have to pay restitution. At this time, I would simply ask that that be left open. I'm a bit perplexed on the Olson auto body estimate. A review of the police report, the damages don't seem to be what is being estimated. I believe there was a kick of a door. So there's a lot of body work there for the hood and fender and bumpers and things of that nature. And also, I believe that this may have been covered with a deductible. So I just ask that that be left open for now until we get enough information to firm up a number. But Mr. Herman certainly is understanding that he is going to have to make the victim whole in this case. Outside of that, I would leave some comments for Mr. Herman. I know that he does wish to address the court.
All right, Mr. Herman, I would like to hear from you. Is there anything you'd like to say?
Well, yes, Your Honor. I know that I always haven't been doing good with alcohol, and that it's a bad thing for me, and that I'm really working on trying to change and be a good member of society and stay sober and keep on doing my probation stuff and make sure everything goes good so I can get this off my record. And that I also start another job, so I'll have 2 jobs and I'll be working even harder than I did before. And so I won't really have much time on my hands to get in trouble or anything else. And yeah, I really want to do it all just so I can be here with my daughter and continue my life as a person.
All right, thank you. And Ms. Wilson, is there anything for the people?
Thank you, Your Honor. We will support, follow the recommendations in the PSI report. And as far as leaving the station open, we have no objections to that.
Okay, thank you. So this is sentencing on the defendant's conviction of assault and battery with the understanding there would be a delay of sentence in the case. And the facts are that the defendant had consumed too much alcohol. He was in an argument with his girlfriend who was driving them home, and at some point she pulled over, he got out of the car. There was another driver that yelled at him to get out of the road and stopped. And the defendant didn't take kindly to that, I guess. He pushed the other driver, and then they started wrestling, and the defendant punched the victim in the face. The defendant had a 0.13 and a 0.14 blood alcohol concentration, and the victim says he had a swollen eye and some abrasions to his knee and his hand or something. And also says that the defendant dented his car, although it's not real clear to me where the dent was. The defendant comes to the court with a prior criminal history that includes an attempt unlawful driving away a motor vehicle in 2016, for which he had an unsuccessful probation, did 15 days in jail. Then there's the trespass in 2017 and the another trespass in 2018. Something tells me all of those had alcohol involved, and that they probably wouldn't have happened except for that. The defendant, to his credit, has had, he's been on PBT testing 4 times a month with no positives or misses. And once a month drug testing. Now, the drug testing shows that the defendant has been using THC throughout, despite bond conditions that don't allow him to do that. So I have kind of mixed feelings about probation, whether it's going to be successful or not. And apparently the defendant has an issue with chronic pain, but his doctor refused to approve him for medical marijuana while this case is pending. Who's your doctor? Yeah.
Yeah, that issue was a bit confusing to me. And speaking with Mr. Herman, I think what he was trying to convey to me is that the paperwork wouldn't be processed by the time that this case would be resolved. But that's my understanding after reading that additional information. Mr. Herman can correct me if I'm wrong on that, but it's not that he wouldn't, but that he wouldn't be able to provide proof of the card by today's date.
Yes, that is correct.
So what's the case there, Mr. Herman?
There, so I was trying to get my medical card because of my one half being bigger than the other. That causes me knee pain. They literally just told me that after I get sentenced and put on probation, that to come back and they'd be able to process my medical card right away, since I already gone through the process of filling it out and all that other stuff.
Okay. Well, let's see. The defendant, also to his credit, seems remorseful, seems to understand he's got a problem with alcohol, and does appear to be a hard worker. He's not only doing construction for his father, but also has taken on a second job, which is always a good idea with a young child at home.
Oh, yes.
The defendant has an 11th grade education, and I hope that you considered trying to finish your degree, because it's really hard to get by these days without a high school education, diploma,
yes,
or GED.
I have thought
Go
about
ahead.
going to school and getting my GED.
Okay, well, now is the time, okay? Because the older you get, the harder it is to do that.
Yes, Your Honor.
All right, given the all of those facts, I will go along with the prosecutor's recommendation for a delayed sentence in this case, which is unusual because I don't usually see that in assault cases other than domestic violence, but with a deferred. But since that was the defendant's understanding, and I don't see a good reason not to go along with a delay, I'll give the defendant that additional incentive to follow through with the probationary requirements, because if you are successful with this probation, I think you'll be in a much better place and maybe stay out of trouble in the future and be productive and a good father and all that. So the fine is $100. Costs are going to be not the $800, but I'll reduce that to $400. The probation is for 1 year. There's a crime victims fund fee of $75. Judicial system fee is $50, and you'll need to repay the cost of your court-appointed attorney, $250.
Okay.
I am going to award the $1,100 in restitution, but if the defendant has objections to that and wants to have a hearing, I'm willing to set it for a hearing as to the damage to the car. Well, okay, I guess that's not going to make sense. I am going to award the $300 for the lost work, the lost wages. That was easy to quantify and makes sense. As far as the $800 for the damage, it is difficult to figure out why there are so many parts of the car that are being repaired. But, you know, fixing any dent on a car, $800 doesn't sound completely far-fetched either. So we'll leave the $800 part open, and I'll leave that open for the next 60 days. During the term of the probation, the defendant is not to consume or possess any alcohol, no marijuana or other mind or mood altering substances. If your doctor does prescribe marijuana for you, there's nothing I can do about that. Apparently, the medical marijuana law trumps everything else in the whole world. So I'm just going to tell you this, that you're 3 times more likely to struggle with your alcohol problem if you continue to use other substances like marijuana. There's pretty good research on that. And so I don't advise it. And I don't think you're doing yourself or your family any favors. There are other medications out there that can deal with chronic pain. Let's see. Although maybe marijuana is not the worst of those either that your doctor might prescribe. So anyhow, I would be very cautious about that and talk to your doctor in detail before you start that. Let's see. No, obviously no illegal drugs or non-prescribed medications. You're not to enter any bars or casinos. I'm not going to extend that to restaurants that incidentally serve alcohol by the glass. And if you happen to have a job that is in a restaurant or bar, I would make an exception for that. You're not to have any contact directly or indirectly with Mr. Hall. You're not to go to his workplace or residence or be within 500 yards of those. You're to be respectful of all court employees and care providers, no violent, threatening, intimidating, or harassing behavior toward anyone. Consistent with the substance use evaluation, you're to attend the basic awareness group. And again, I think the assessment is good. The defendant does admit he's got a problem with alcohol, and now is the time to do something about it while you're still young and before you rack up more of a record here and things become kind of unmanageable. You're taking it past random alcohol testing. Let's see. We'll continue the 4 times a month since you've been successful with that. Drug testing is going to be 1 time per month. The probation office can adjust those down if you're doing well. And let's see. There will also be discretionary testing for both drugs and alcohol. The jail time, it's recommended that I give you 7 days. And frankly, given your past record, this is your 4th criminal conviction. I think the 7 days is appropriate. Let's see. With the 1 day for credit, which was probably just getting booked in, and the 1 day of good time you'll get, that's really 5 days. So I think that's appropriate. So that's what I'm going to go with, is the 7 days. You'll need to turn yourself in. I'll give you until tomorrow at 5 p.m. That's Friday. Let's see.
Is that to
Your
Grand
Honor.
Traverse or the?
Yeah, Mr. Rassby.
Would he be eligible for work release?
You'd have to talk to the jail about that. And that is the Grand Traverse County Jail. This is a Grand Traverse County case. If they want to
This
send
one
him to
is.
Leland, maybe they can put him on the bus and send him up there. But I think it's kind of screwy that I'm supposed to tell him which jail to turn himself into.
Okay.
So which one?
Yeah, I'm
All right, you're going to turn yourself into the Grand Traverse County Jail Friday by 5 p.m. Yes, and after today's hearing, but after 1 p.m., you need to contact the number on the pre-sentence report, the 922-6899. They'll go over the conditions of probation in more detail with you, answer any questions that you have, and that's it. Anything else for you, Mr. Ransby?
just if the jail is permitting work release, you're permitting that as well. Is that?
You know, I'm not going to allow work release. You know, this is punishment. This is the fourth conviction. He's being given the ability to have a delay. There's an attempt UDA on his record where he's already done 15 days. He didn't learn his lesson from that. So I think I'm going kind of soft with the 7 days. And no, this is, you know, he needs to sit and all right, so that's it. All right, anything else, Mr. Asby?
No, that's everything.
Or Ms. Wilson? Okay,
Nothing, Your
so
Honor.
we're all
Thank you.
set. Okay, we're all set for today then. Good luck to you, Mr. Herman. I hope this basic awareness group is helpful for you, and you're all set. Feel free to sign off at this time, okay?
All right, thank you.
Yeah. All right, let's see. This is file 9192214 SM, People versus Daniel Hennigan. And let's see, Ms. Claxton is here for Mr. Hennigan and Ms. Wilson for the People. This is the date for sentencing on the defendant's convictions of malicious destruction of a building less than 200 and attempted domestic violence second. Ms. Claxton, if you had an opportunity to go over the pre-sentence report, and is it accurate and complete?
Your Honor, it is accurate. I did want to address one thing, which is the issue of credit for time served.
Okay.
So essentially, Mr. Hennigan had an accompanying felony case for which he was on probation for. He had some probation violations, and I believe that this case was one of them. He turned himself into the Benzie County Jail on March 1st of 2021. He had a bench warrant out in this case. And Grand Traverse County did try to arraign him in March. However, there were some video issues in the Benzie County Jail. And so he didn't subsequently get arraigned until May in Grand Traverse County, but he had been sitting since March 1st. And so I guess we would respectfully request that he get credit since March 1st for this case as well.
All right, Ms. Wilson, any response from the People?
The people have no position and would leave that to the discretion of this board. Thank you.
Was there a hold on the defendant from our jail?
There was a warrant out, I know, Your Honor, from his failure to appear in the past. And so they tried to arraign him, I believe, March 26th in Grand Traverse County. And there were video issues, so he wasn't on the line, and then it wasn't rescheduled until May.
It just seems odd to give him credit when he hadn't been placed on any bond in this case. You know, a bench warrant isn't bond. I suppose if he had been arraigned back in March, he would have been placed on a bond, but so I think this is a purely equitable matter. And when I look at the equity of it, here he's in jail on a probation violation in Benzie County. Why should he get credit for something that was completely unrelated to that offense? Or was he in jail and was the probation violation this case?
It was my understanding that, yes, this was a part of the probation violations.
Just a part of it?
I guess Mr. Hennigan can explain what all of the counts were, but I do know that this was one of the counts of probation violation.
All right, Ms. Odom seems to have more information.
Whether or not this bond, he was given pre-complaint bond on October 17th, 2019, if that makes a difference. I don't know.
What date?
October 17th, 2019. And it was pre-complaint because it was a DV case and he hadn't been arraigned yet. It was a PR, 10,000 with conditions. And then he failed to appear for his arraignment, as Ms. Claxton had mentioned, on October 24th, 2019.
Okay, so a bond was set, but it was a PR bond.
Mm-hmm. Right.
And I believe that would have been revoked based on his failure to appear.
Mm-hmm.
And so when was the bench warrant issued, Ms. Odom?
Failed to appear arraignment, forfeit bond issue bench warrant, October 24th, 2019.
Okay, all right. Well, I think that given those circumstances, I will give credit. So that's from March 1st. That's the date he went into the Benzie County Jail, Ms. Claxton?
Yes, that's correct. He turned himself in on March 1st.
Okay, so that's 4 months of credit. Or 120 days. All right, anything else with the report, Ms. Claxton?
No, Your Honor, thank you.
All right. Let's see, what would you like to say then on behalf of Mr. Hennigan?
Thank you, Your Honor. Your Honor, we've seen the report and the recommendations. Respectfully, we agree with the recommendations for a straight jail sentence. I think that makes the most sense in this case. I guess the question for the court is how much jail. As stated, he did serve about 4 months in the Benzie County Jail. Prior to this, he just got out of the Benzie County Jail just a couple of days ago. Since he's been out, he has been in contact with.
What day did he get out exactly?
I believe
the report seemed to indicate he was in jail. I guess he doesn't look like he's in a jail right now, but so when did he get out? What day?
I believe Tuesday, Your Honor.
Okay, so that would be, is that right, Mr. Hennigan? You got out Tuesday? Oh, you're muted, sir. Can you take yourself off mute?
Sorry about that. Yes, Your Honor, Tuesday was when I was released.
Okay, so we'll make it 118 days. All right, thank you. Okay, go ahead, Ms. Claxton. Sorry to interrupt.
No problem, Your Honor. I apologize for not clarifying that. So Mr. Hennigan did sit about 4 months prior to the sentencing. He just got out. He has been in contact with employment. It sounds like he has potential employment should he be staying out of jail. So I guess the question for the court to decide today is, does it make sense to send Mr. Hennigan back to jail for a little while longer for this case, or does it make sense to just give him credit for time served today and allow him to get that employment opportunity? So we would just leave that up to the court today, Your Honor.
Okay, Mr. Hennigan, is there anything else you'd like to add?
I would like to just apologize for my previous actions. Upon March 1st, turning myself in, I was selfish before. That turning myself in was changing to try to take responsibility for everything in my past. Suppose that's all, Your Honor.
All right, thank you. And let's see, Ms. Wilson, is there anything for you?
The people would just ask that this court follow the recommendations in the pre-sentencing investigation report. Thank you.
All right, thank you. So this offense, which occurred back in October of 2019, involved the defendant and his girlfriend. The facts are that the victim states that the defendant was, well, it started, he threw a bag of pop cans at her. The victim went back in the house and the defendant was yelling and eventually punched a glass door, shattering it. And the victim also states that the defendant grabbed her by the hair and took her to the ground. The defendant disputes much of what happened other than pulling the hair. The defendant comes to the court with a long prior criminal history that involves, well, there was a juvenile adjudication for a felony larceny in a building, another juvenile adjudication for attempted B&E, MIP retail fraud third, MIP second. Then there's a home invasion, second degree in 2015. And that's the offense that we were talking about earlier. And while he was on probation for that, this offense occurred. Then there's the attempted domestic violence in 2016 and a drug offense in 2018. So not a good record here. And the defendant, in my opinion, after looking at all the facts, I think he's minimized what happened. In fact, he told the probation officer he laughed about the police report, blamed the officer for not getting the facts straight. However, those facts were supported by the victim. And the victim, by the way, based on her impact statement, didn't want prosecution. So why she would make things up doesn't make any sense. The defendant admitted that once he got a PR bond back in 2019, he went missing in action, as he put it, and went back to living with the victim, even though that would have been a violation of the no contact order. And so based on the lack of accepting responsibility, lack of cooperation with bond, and the prior criminal history, and fact he was on probation at the time that this happened for a felony, I think the only logical decision is to give him the 180 days with credit for time served. again, when I go back to the equities in this case, the fact that the defendant purposely violated the bond, went, as he put it, MIA, knowing that there was a bond in place back in 2019. I don't think it's fair that he gets credit for the Benzie County time, but I think as a legal matter, he's entitled to it. But I wouldn't give it to him other than that. So there will be no probation. The fine is $100. Costs are $400. Crime Victims Fund 75. Judicial System fee is $100. There's a court-appointed attorney fee of $250. And the jail time is 180 days with credit for 118 days already served. You need to turn yourself into the Grand Traverse County Jail by 4 p.m. this afternoon. Anything else for you, Ms. Claxton?
No, thank you, Your Honor.
All right, Ms. Wilson, anything?
Nothing, Your Honor. Thank you.
Okay, thank you. You're all set, Mr. Hennigan. Feel free to sign off.
Thank you, Your Honor.
All right, we have a competency hearing on Parzich. He's in the jail?
I don't know where Mr. Parzich is.
Oh, he'd be coming to us from the Forensic Center.
I would
wouldn't he?
think.
Okay.
What's the last name?
Harry Parzich. No, Parzich, P-A-R-Z-Y-C-H. I believe he's at the Forensic Center, probably in Mount Pleasant,
I think you're right.
being restored to competency. So let me know when we're ready to go on that.
Sure. Oh, yeah.
There's Cynthia.
Oh, hi, Miss Conlon.
Hello.
There you are. Thank you, Bob.
Thank you,
I
ma'am.
appreciate it. Our guest is Mr. Parzich is at the Forensic Center.
Yes, he is.
Yeah. All right, as soon as we get a prosecutor here, we'll get started.
Okay.
Hi, Ms. Wilson.
Hello.
Okay, we'll get started. Let me grab the judge here. We're ready, Judge. Okay. I'll be out shortly.
All right, good morning. This is People versus Harry Parzich, file 203325FY. And Ms. Conlon is here on behalf of the defendant, who is not present. Let's see, Ms. Wilson is here from the prosecutor's office on this CSC first degree complaint. And let's see, the opinion of the forensic center that I received concludes that the defendant is still incompetent to stand trial, but says that with continued medication and treatment, they believe that he may be restored to competency within the time allotted by statute. So, Ms. Conlon, what is your position on behalf of your client?
Your Honor, it's my understanding that they have up to 15 months to make him competent. So my position is they should still continue to attempt to render him competent.
Okay. And with regard to your client not being here, would you agree it's not essential for a fair hearing on this? That
I
he
agree.
be here today?
Yes. Yes, I do agree.
All right. Ms. Wilson, People's position.
Oh, we share the same position as Ms. Conlon. We would ask that he remain in their care and attempt to return him to competency for trial.
Okay. Well, there being no objection by either party to the conclusions of the forensic center, we'll continue trying to restore Mr. Parzich to competency. And let's see, we're still well within the 15 months because the original referral to the forensic center was back in October. So no problems there. So, okay, anything else for you, Ms. Conlon?
No, thank you.
Ms. Wilson?
No, thank you, Your Honor.
All right, thank you.
Thanks, Judge.
Yep.
Okay. Not till 9:30 now.
Okay, we'll be in recess
Yep.
till 9:30. Our 9:30 ever show up?
Not yet.
That's odd.
I know. Is anyone here? Mm-mm.
Okay.
I know. Oh, wait a minute. There's Mr. Warden. Hi, Mr. Warden.
There's Mr. Warden.
Sorry, I didn't know you guys were here. They just were sitting in the background.
Okay.
Okay, come on in.
All right, good morning. This is
Morning.
versus Matthew Colombo, file 215119 SD. Mr. Warden is here on behalf of the defendant. And this is the date for sentencing on the defendant's conviction of operating while visibly impaired. So, Mr. Warden, have you had an opportunity to go over well, there was a report, but not a PSI. And let's see, I've received the psychotherapy intake note and the follow-up from Mr. Rossi at Third Coast Counseling, indicating that the additional counseling session was completed. So let's see, what would you like to say then on behalf of Mr. Colombo?
Thank you, Your Honor. This is an unfortunate case given Matthew's young age. He's 17 years old when this happened. But it's also a good learning lesson for him at such a young age because he has quite a bright future ahead of him. If you look at the letters of support, he's gainfully employed. He works at the filling station down here by my office. He appears to be a very bright and organized and good employee for them. He's interested in airplane mechanics, aeronautics, is college bound. He definitely has the support of a very nurturing family. And this is out of character as they report to me. Now, out of character is tough to say when you're talking about alcohol usage and driving with a 17-year-old. It should be out of character at that age. What I've been impressed with Matthew for, though, is kind of realizing that and taking the steps appropriately to make sure that this doesn't happen again, that this is a blip on his radar. And what he and I have talked about a lot is, 2 points do make a line. One offense like this is not liable or likely to close doors, but if something else like this happens again, that would make the second point, and that would make a line, and that could have a dramatic effect on his young life. So proud of him for taking the steps that he's taken, and I would ask the court consider, if probation is appropriate, a very short probationary term. Thank you.
All right, thank you, Mr. Warden. I would like to hear from you, Mr. Colombo. Is there anything you'd like to say before I sentence you?
Yes, Your Honor. First, I'm deeply sorry to my parents who were worried for my life, in which they did not know where I was on that night and did not know if I was okay. That is a position I would never want them to be in again. I also want to apologize to the Kepler family and the Eshelman and Lesk family for their concern that night. I'm embarrassed and disappointed in the actions that I made that night, which could have ended very differently. I could have severely injured not only myself, but other people, and I'm very thankful it did not end like that. I know how severe the consequences of my actions can be, and I never want this to happen again. I will be living with the repercussions of this for the rest of my life. Although this is a terrible experience that I know that I would not wish on anyone, I have already learned so much from my actions and will continue to learn through the rest of this process. This is a position that I never thought I would be in, and I am extremely regretful of my choices. I know I will not let this happen again. It was a first and last time. Thank you, Your Honor.
All right, thank you, Mr. Colombo. So this is sentencing on the defendant's conviction of impaired driving. He was originally charged as an operating while intoxicated. The facts are the defendant was left a bonfire after consuming alcohol, which for him, he shouldn't have been consuming alcohol at all. He was in the 11th grade. Apparently there was at least one other gentleman at the bonfire who thought that the defendant was okay to drive, which tells you how concerned your friends were about you. It turns out that Mr. Colombo pulled into, I'm going to assume, a neighbor's yard because he did recognize he'd had too much to drink. He was found by police officers after there was a call of concern, passed out in the car, having vomited all over himself. So the friends that you were hanging out with there were not doing you any favors that night, I can tell you that. I think Mr. Warden put it very well. You've got a lot of potential, and and a very supportive family, and I wouldn't want to see anything happen that would derail that. And fortunately, nothing terrible happened in this case. Mr. Warden and I could both tell you about the drunk driving incidents that haven't ended so well, with people horribly injured and dead sometimes. I appreciate the fact that you've apologized to your parents today, because there were people out looking for you that night and trying to figure out where you were at. And that's every parent's worst nightmare, of course, is not knowing what their kids are doing and concerned about their safety. And so I appreciate those statements. On the bright side here, this is the first involvement with the criminal law for Mr. Colombo. He does appear to be someone who's taking this seriously. He has completed a psychotherapy intake, or a substance use assessment, essentially, with Third Coast Counseling. He has completed proactively the sessions that were recommended by Mr. Rossi. The conclusion, the diagnosis of that was alcohol intoxication without use disorder. Now, it's always hard because these are, for the evaluator, these are based on self-report of what's going on in the defendant's life. But based on everything that the assessor knew anyway, there's no substance use disorder. I am concerned and surprised a bit that you weren't placed on any regular testing when you were released on bond. It would be more typical that you'd be testing on a regular basis with random preliminary breath tests, and that did not happen in this case. And so there's very little for me to go on as to whether or not the defendant has truly stopped using alcohol as he was ordered to do. I didn't see where any discretionary testing was ordered. And so based upon all of that, what I'm going to do is I am going to sentence the defendant to a short term of probation. It's going to be 6 months. There will be an opportunity to review that at 3 months. The purpose of the review will be that if you're doing well, you haven't tested positive, then we'll go ahead and terminate the supervision. but I think there should be a period of abstinence that is verified by the court, and we're going to do that with 8 times per month alcohol testing, and there'll be a urine screen for drugs benchmark today, and as long as that's clean, it'll be discretionary testing for controlled substances. The probation department will have the ability to reduce that testing at some point if you continue to do well. Typically, what I look for is 3 months of being able to comply with the court's conditions to feel safe that there's not more going on here than just the one-time incident. Hopefully, that's all this was. The other conditions of probation are going to be, first of all, that you not possess or consume any alcohol, which shouldn't be a problem since you're not 21. No mind or mood altering substances, including marijuana, no illegal drugs, obviously, or non-prescribed medications. If you do have a prescription, you need to provide a copy of that to the probation office. You must be respectful to all court employees and care providers. There will be 3 days of community service work. I think given the risk of safety to the public, you need to pay your dues on this, and that's going to be in the form of community service work. So 24 hours of community service work to be completed by the end of probation. Let's see. I would make exceptions to possession of alcohol only for employment purposes. So if for some reason you're to get a job in a restaurant or a bar, that would be acceptable. You're not to operate a vehicle without a valid license, registration, and insurance, and you're not to operate a motor vehicle with any amount of the substances that I described earlier. All right, so that is the sentence of the court, and I do think that you're taking this very seriously. Your comments today were very thoughtful, Mr. Colombo, and I hope that this was a one-time incident, that you learned from it, and I want to underscore one more time what Mr. Warden said about limiting your opportunities when you get a criminal conviction. This is something that's manageable, but if you were to continue down this road, your opportunities are going to begin to limit themselves. And you don't want that to happen, especially at your young age. I don't want to see that happen. And so anyhow, let's get through this probation successfully. And I hope to sign a successful discharge from probation in 3 months. So anyhow, we're all set for today. Feel free to sign off at this time. Thank you, Mr. Warden.
Your Honor, you didn't assess my house.
I thought I did. $100 fine, $200 cost, 75 crime victim, $50 judicial system fee. And I assume you're retained, Mr. Warden?
I am, Your Honor. Thank you.
Okay, so those are the fines and costs. And and one other thing, Mr. Colombo, you need to contact your the probation office today. Mr. Warden will give you the number, 922-6899, and they will go over the conditions of probation in more detail with you, answer any questions that you have about it.
Yes, Your Honor. Thank you.
Thank
Okay,
you.
we're all set. Thank you. All right, what do we got left? I can't understand why that was a non-public record. It's a drunk driving case.
I didn't put delayed on there or anything. Was it supposed to be?
No, you
Oh.
can't delay a
Yeah.
drink. Well, I don't know if you can, but the prosecutor never has agreed to that. So
Right.
I thought it was odd.
That is weird.
All right, we got Garrett Jackson at 9:45.
I'm here, Your Honor.
Oh, you're here, Mr. Garrett Jackson?
Yes, sir. I just don't have video. My service is very horrible at work.
Your Honor, if I could go into
Okay,
a brief breakout room with Mr. Garrett Jackson, I'd appreciate it.
No problem. Look for an invite on your device to pop up there, sir. Are you at the are you at the 632-3791 phone number?
Yes, Your Honor.
Okay. Should go out right now. Let's see. Do we have Michaela Miller present?
Here's Ms. Claxton.
Okay, I see a Bree McCarty. I just wondered if maybe that was Ms. Miller.
No, Ms. Claxton had sent me an email letting me know she'll need a breakout room if she shows up, but she hasn't had, she hasn't heard from her since her pretrial.
Okay. All right, is that Ms. Miller connecting on the Galaxy phone?
Yes.
Is that you? Okay, I'm going to rename you here. Your attorney would like to speak to you before the hearing. And I'm not able to do that until Mr. Warden gets back.
Okay.
All right. Got a search warrant that is in the works.
Okay.
The officers should have sent it to your email.
Okay, I'll look.
All right, I'm gonna close out the breakout room. Mr. Warden's back, and I'm gonna put Ms. Claxton and Ms. Miller in the another breakout. Okay, so I'm gonna rename Mr. Garrett Jackson. There we go. Okay, so Mr. Warden, have you had a sufficient opportunity to speak with your client, and are you prepared to go forward with sentencing?
I have, Your Honor. We reviewed the pre-sentence report, the substance abuse assessment. We find them factually accurate. We are prepared to go forward with sentencing.
All right, so then what would you like to say on behalf of your client?
Your Honor, I do think that this is a very reasonable workup by Ms. Stanachuk. I think he does need probation. I'm mindful of the fact that he has several unsuccessful probations, going back to 2010 through 2014, even 2018. I'd like to see Alante have a chance. I mean, this case has been going on since mid-February. He has been cooperative on bond. He does have 2 stumbles in February and in June that were positive alcohol tests that were already addressed by this court and then the circuit court. I do also think that the probation workup will give him the opportunity to maintain employment and to be otherwise productive and get some of the therapy that's recommended under his belt, because that's really what he needs. What I'd like to see the court do is hold the 90 days that is recommended for jail time in advance, because that is something that is a heck of a carrot and a heck of a stick for Mr. Garrett Jackson. If there is anything that does happen in the interim that plunks down in his head and he has to deal with it. But in the short term, I'd like to see him have the opportunity to do an extended term of probation to get the counseling under his belt and to be otherwise successful. So those are my requests here.
All right, thank you, Mr. Warden. Mr. Garrett Jackson, is there anything you'd like to say before I sentence you?
Yes, Your Honor. Like Warden said, I know my track record is not very good on probation, but this last 5 months I've took this so serious, and it actually improved my life without using alcohol. And I would just like the opportunity to prove to you guys I can be successful on probation and get through this and get the help that I do need. I've been doing counseling at the Traverse City Health Clinic and opening it up and learn myself again. And I think I can succeed this time. And if you give me the opportunity, I promise it will not regret it.
All right, thank you. Okay, so this is sentencing on defendant's conviction of malicious destruction of property, 200 to 1,000, and OWI. The original charge, it should be noted, was a felony, home invasion third, and habitual offender third offense. The facts are the defendant was intoxicated. He admitted to consuming 7 beers before this happened. He drove home. The doors were locked, although there's a dispute, obviously, about whether this was his home or not. His girlfriend called the police. She said that he was not allowed at the house, that they had broken up and he wasn't living there. And the defendant anyhow broke a window to get into the house. That's the home invasion. And also sent texts threatening to break the windows in the gentleman's car that was staying there at the house with the girlfriend, the ex-girlfriend. And he also threatened to kill him. So the defendant comes to the court with an extensive prior record. This will be the 10th conviction for Mr. Garrett Jackson. Of those, some of them are as minor as MIPs, 2 of them, but then we've also got a felony for manufacture of narcotics. There was an unsuccessful probation in that case, 9 months in jail. There's another, let's see, attempt police officer, resist and obstruct, and domestic violence. again with unsuccessful probation in 2018 and 93 days in jail. And then there's a 2019 domestic violence, 93 days in jail. And so you kind of see where you're at here, Mr. Garrett Jackson, that the court's kind of tired of seeing you back in court, and the tendency has been to just max you out as of late, rather than hope that something's going to change. Now, to the defendant's credit, he is gainfully employed at Glen Arbor Outdoors, apparently working full-time, making good money. He has expressed remorse for his conduct here today, and says he's taking this very seriously and wants to be successful. So what I'll say is that at age 30, Mr. Garrett Jackson, you know, maybe you have decided that you're tired of going back and forth to jail, and you'd like to have a different kind of life for you and your kids. And so I'm willing to give you that opportunity, but there is going to be some punishment in this case, as well as an opportunity to show that you have changed. So I am going to place you on probation for the recommended 18 months. That is appropriate given the fact that this is a felony that has been reduced to a misdemeanor, but the facts of the felony home invasion are there. It's also appropriate given the defendant's long prior criminal history. It may be inappropriate given that so many probations have been unsuccessful in the past, but Ms. Stanichuk is willing to take a chance on the defendant, apparently, and so I'm going to go along with that too. The fine will be $200. There's a cost of $400. Crime Victims Fund is $75. Judicial System fee $100, and there's a $650 court-appointed attorney fee, $125 arresting agency fee, and the prosecutor blood draw fee of $22.30. During the term of probation, you're not to consume or be in possession of any alcohol, marijuana, no illegal drugs, or mind or mood altering substances, no non-prescribed medications, and you're not to reside where those are present. You need to verify all prescription medication with your probation officer by providing a copy of those to her. You're not to enter any bars or casinos or establishments that serve alcohol by the glass unless that is for work purposes, and you need to verify that first with your probation officer. You're not to possess or reside where there are weapons or firearms present. You're not to have any contact with Bree McCarty or Xavier Cox. And you're not to go within 500 yards of their residences or workplaces, and you're not to go to King's Court. I just realized we have Bree McCarty here today, and I did not give her an opportunity to speak if she wishes. And so, Miss McCarty, I'm sorry, I did see your name on the screen there earlier. Unfortunately, didn't connect it with this case, but is there anything that you would like to say before I sentence the defendant? Ms. McCarty? All right, I'm going to take that as a no. All right, so we'll go back to the sentence then. You're not to be within 500 yards of Bree McCarty or Xavier Cox's residence or workplace. You're not to go to King's Court for any reason. You're not to behave in a violent, threatening, intimidating, or harassing manner toward anyone, and be respectful of all court employees, and service or care providers. You're to attend and cooperate in the Alcohol Highway Safety Program and Victim Impact Panel. Attend and cooperate in the men's program. No unexcused absences. Continue to attend your counseling at Traverse Health Clinic and follow all the recommendations without any absences unless excused in advance. You're to take and pass daily morning preliminary breath tests, and drug testing will be once per month. The probation office may adjust those testing requirements in their discretion. Exchanges of children are to be done through a third party. And apparently your father's been taking care of that third party role, and that's fine. You can continue with that. There will also be discretionary testing for both drugs and alcohol. With regard to the jail time, Mr. Warden is recommending I hold all of that time over your head as an incentive for complying with the probation conditions. And I will say that the best thing for you and also for public safety would be to see you complete this probation successfully. But given the fact that this is in reality a home invasion third, the fact that it's your 10th conviction, the fact that the behavior in this case on the heels of 2 prior domestic violence cases, I see this as, even though it's not technically domestic violence, it certainly had those overtones about it. So I'm not going to give you the 90 days, but I will give you 30 days in jail. You need to understand that I'm serious about putting you in jail if you're not going to comply. But if you do not meet all the conditions of this probation, you can pretty much anticipate that you're going to end up with the whole year in jail. I'm just going to tell you right now. Okay.
Yes,
you need to make a serious effort here, or it's going to get really difficult for you. So I don't see a reason for community corrections to review the case given that sentence. So I'm not going to go along with that. You're to obey all court orders with a friend of the court, probate court, and any recommendations of CPS. And you're to notify your probation agent of any contacts with law enforcement. Is there anything else for you today, Mr. Warden?
No, Your Honor. Thank you.
All right. Thank you. We're all set for today, Mr. Garrett Jackson, but I do need you to turn yourself in. I'm going to give you until Friday at 5 p.m. That'll give you a chance to speak with your employer and hopefully get things straightened away there. You're fortunate that the job market is so desperate for employees right now, and probably you'll be able to hang on to that or get another job somewhere else. All right, so 5 p.m. Friday, I do need you to contact your probation officer, Ms. Stanichuk. Prior to that time, there's a phone number listed on the pre-sentence report, or you can get that from Mr. Warden. We're all set for today. Feel free to sign off.
All right, thank you, Your Honor.
Thank you. Okay, let's go to People versus Seth Anthony Weber. And Mr. Weber is here with his, well, you're unrepresented today. Is that correct, Mr. Weber?
I have Cynthia Conlon, Your Honor.
You do? Okay. She's not listed on the probation violation report for some reason. Did you request an attorney at the time you were arraigned on the probation violations in this case?
Yes.
Ah, there she is. Ms. Conlon.
Here I am.
Are you representing Mr. Weber?
I am.
Okay,
Thank
I
you.
was confused because the report doesn't list an attorney. So anyhow, have you had an opportunity to review the report with your client, and is it accurate and complete?
This is a probation violation hearing, Judge. Yeah, I did review the alleged violations and Ms. Morton's recommendations.
All right, so what does your client wish to do about the hearing?
Your Honor, I guess my client admits the allegations about missing random UA and the positive THC tests. With regard to the allegation about the 3 12-step meetings a week, he recalls that he has attended all the meetings as ordered. However, I think from looking at the records he has and consulting with Ms. Morton yesterday, I think he is still some meetings shy on his verifications anyway of what he was ordered to do. So with regard to that one, we just defer to what the records say. But on the other ones, Your Honor, he does admit those.
All right. What do your records indicate, Ms. Morton, regarding the 12-step meeting verifications?
This is a case where this he got transferred to me June 1st. So Miss Moore actually presented or started this. So when she says 3 12-step short, I would go with that. I haven't had a chance to go back and look at all of them to count.
Okay, so I guess what she's saying is he's ordered to do 3 times weekly, and he's missed at least 3 of those as of May 27th.
Correct.
Okay. All right. So, Mr. Weber, your attorneys indicated that you wish to take responsibility for missing and testing positive on these tests, and for the misses on the, well, whatever the records say for the 12-step meeting verification. Is that correct? You want to plead guilty to those?
Yes, Your Honor.
All right. You understand that the worst that could happen is your probation could be revoked and you could be sentenced to up to 180 days in jail for a violation of your probation. It's not what's being recommended, but that's the worst that could happen. You understand that?
Yes, Your Honor.
All right. And has anyone threatened, forced, coerced, or promised you anything to get you to waive your right to a hearing today?
No, Your Honor.
All right. Then is it true you were placed on probation for high BAC back on January 12th, 2021? And as a condition of that probation, you were to take and pass drug screens. Is that true?
Yes, Your Honor.
All right. And you were also ordered to attend 3 12-step meetings per week, correct?
Yes, Your Honor.
All right. So is it true, as stated in the report, that you missed your random UA on April 6th and tested positive for THC on 4/30, 5/6, 5/13, 5/19, and 5/24?
Yes, Your Honor.
And is that the positive test, is that because you did in fact consume THC?
Your Honor, I was consuming catnip tea for anxiety at night.
Okay, and did that contain THC? I mean, is that what you're saying?
No one else agrees with me except for Google, but that it can give you a false positive for marijuana.
So you're denying that you were using marijuana then?
At the time, yes.
All right. And there's no medical marijuana card here. You don't have one of those, right?
Yes, sir. Or yes, Your Honor.
He does, Your Honor, but it was reinstated as of May 25th.
All right. Then as far as the meetings that you were to attend, sounds like you've gone to most of those, but you are in agreement with Ms. Morton or Ms. Moore that you missed 3 of those meetings. You're not contesting that.
I thought for sure, Your Honor, that it was covered under my paperwork. It shows that it is.
Okay, well, this is the thing. I'm not going to accept any pleas today. If you want to have a hearing on this, Ms. Conlon, that's fine. But the defendant's denied using marijuana. He's denied missing any of these meetings. And if you want to have a hearing, that's fine. We'll do that. But otherwise, I would be sentencing the defendant on 1 out of about 1, 2, 3, 4, 5, 6, 7 violations. So what do you want to do?
I mean, he has been testing positive for THC. I mean, that he's not
but he
supposed to
says
test
it's
positive
catnip.
Well,
He says it's catnip.
Well, I can assure you, Your Honor, I didn't tell him to say it was catnip.
Catnip tea. Okay. Well, I'm going to sentence him on the full load, and if he wants to take responsibility for it, but we'll have a hearing first before I do that. I'm not impressed at this point, I can tell you that. So maybe you want to have a hearing on this. Do you need more time to prepare?
No, thank you.
All right. So, Ms. Morton, are you prepared to present proofs?
I believe so.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth?
I do.
All right. You put your hand down. So, what evidence do you have to show that the defendant missed a random urinalysis on April 6th?
I believe I provided all of the missed and positive tests as well as the confirmation tests to both Your Honor and Ms. Conlon from New Directions, showing the positive for THC, and there was a confirmation test as well. I believe those were both provided. As I said earlier.
So the confirmation test was from May 13th, is that correct?
Let me look. Yes, there was a confirmation test from May 13th. that detected THC.
And that's a report from what, Redwood Toxicology Laboratories?
Yes, that's from Redwood.
And there was also a dilute sample with a 16.5 nanograms per deciliter creatinine on May 6th, according to your records.
That is correct. That also was positive for THC as well.
All right, and the defendant has stated in the past that he used to have a medical marijuana card and said that talked to Ms. Moore or you about THC being a herbal supplement and I guess trying to encourage you to allow him to use the THC, or I don't know what the point of that was.
Yes, on May 10th, the defendant called Ms. Moore. He said his last marijuana card had expired in 2017. He said THC is an herbal supplement to sleep. He chose to pay for the confirmation panels. He paid for the confirmation. I believe she gave him a warning to have clean urine samples until he had a medical marijuana card, which he was able to provide the medical marijuana card, as Ms. Conlon said, in May, after these tests.
All right, so with regard to the 312 step verifications, your records indicate that he's 3 meetings short of the required number. Is that correct, as of May 27th?
That's what my records show for Ms. Moore, yes.
All right, Ms. Conlon, any questions?
I don't have any questions, Your Honor. Thank you.
Okay. Any other evidence you want to present, Ms. Conlon?
No, Your Honor, except to note that apparently Mr. Weber's card was issued effective May 25th. However, he had also provided to Ms. Moore the doctor certification form saying that he was approved for his medical marijuana card on May the 12th. So he was actually approved for the card before he actually received it. So I would just note that for the record.
All right, thank you. So no other evidence? Mr.
No,
Weber
thank
doesn't
you.
wish to testify? Okay.
I think Mr. Weber's already told you his position, Your Honor.
All right, anything else you want to add before I decide what to do?
Well, Your Honor, I think it's noteworthy. Mr. Weber has maintained employment throughout this matter, both before he was convicted and placed on probation and subsequently. Before, subsequent to the incident that formed the basis of this charge, he had entered into substance abuse counseling with Laura Miller at Munson Behavioral Health. And I know that Ms. Miller has confirmed to probation that he is attending counseling with her. He continues to do that. And so, Your Honor, I think that those are certainly positives in Mr. Weber's favor. This is not someone that just fell off the wagon and is doing nothing to address his problem. He does continue to do substance abuse counseling and to be employed.
Okay, anything you'd like to add, Mr. Weber?
No, Your Honor.
And Ms. Morton, anything you'd like to add?
No, Your Honor.
All right. Give me me a couple minutes here. All right, the defendant was sentenced on January 12th of this year for a high BAC offense. Defendant crashed his car into another vehicle. Says he rear-ended a stopped vehicle at a stop sign. And the PBT was a .297, but the blood draw was a .17. Seems like a big discrepancy there. When the defendant was on bond, he did test positive for THC throughout and in addition opiates, and there's been no explanation for the opiates. The substance use assessment indicates that the defendant has a severe substance use disorder, alcohol use disorder specifically. But it also indicates that at the time he's committed to recovery and motivated to comply with the court. He has attended Munson Behavioral Health for counseling, has done most of the meetings that were ordered, the 12-step meetings. This was the defendant's first involvement with the criminal law. And I'm just going to say with regard to the I don't understand for 1 second a doctor knowing that someone has a serious substance use disorder prescribing marijuana. That is so inconsistent with common sense. And the fact is the defendant was using, before he got this card that they hand out like popcorn, the idea that these are for medical reasons, I just, you know, I guess I'm just supposed to pretend I'm an idiot here, but I know that you can get one of those cards in about 30 minutes. I haven't heard of any reason why someone would prescribe marijuana to this defendant in particular. I don't know what the health concern is. The defendant also tested positive for opioids, and specifically he was ordered not to use hydrocodone. I guess I'm going to assume that's what he was using. All right, the recommendation is to just discharge this defendant unsuccessfully from probation. Apparently, Ms. Morton just would prefer to have you go away, but that doesn't seem to fit with public safety in this case. Someone with a serious substance use disorder who's driving around with a .17 and hits another car. So I'm going to try to do something productive. The defendant will continue on probation. The defendant is to serve 5 days in jail for the violations in this case. Otherwise, all conditions of probation are continued. The defendant apparently does have a medical marijuana card. And so for that reason, as long as he's provided a copy to his probation officer, there's nothing I can do to stop him from using that. But I would ask him to report that and his continued use of marijuana and opioids to his 2 months in behavioral health. And report all of these violations 2 months in behavioral health, provide proof that he's done that to the probation department, and follow any additional recommendations that they have. The defendant is to report to the jail for 5 days, beginning this Friday by 5 p.m. And that's it.
Okay, thank you.
Thank you. All right, is Ashley Middow present? Ashley Middow? Apparently not.
Your Honor, I'm here from Mr. Minnow. I can give her a call and see what's going on. I believe she should be here.
All right, if you want to take a moment to do that, we'll go on.
Do you want to take
Our
a,
next case isn't till
you have
10:45.
Michaela Miller.
Okay, so is Miss Miller, is that you on the LG phone?
No, this is Ashley.
All right, let's see, what happened to Ms. Miller? Is she still stuck in the breakout room?
She's on the Galaxy, Your Honor.
Okay, Miss Miller, is that you on the Galaxy A01?
Yes, Your Honor.
Okay. Next time you're in court, if you could please rename yourself so I know who you are, that would really be helpful. As it
Okay.
indicates on your notice.
I just don't know how to do it.
All right, so this is People versus Michaela Miller. That's file 215235 SM. Ms. Claxton is here on behalf of Ms. Miller. And this is the date set for a probation violation hearing. Ms. Claxton, what does Ms. Miller wish to do?
Your Honor, this is actually the date set for a plea after a pretrial conference.
I'm sorry about that. So, all right, is there a plea offer?
There is, Your Honor. Ms. Miller was charged in a 2-count complaint, 2 counts of domestic violence. It is our understanding of the plea agreement that she may plead guilty to 1 count of domestic violence under a deferred sentence, and in exchange, the balance would be dismissed.
All right. Is there anyone here from the prosecutors? Oh, Ms. Wilson, is that a correct statement of the plea agreement?
Yes, in addition, she would not request early release from probation.
Okay, so Ms. Miller, is that your understanding of the plea agreement? You're going to plead guilty to 1 count of domestic violence. The other count would be dismissed. And you would receive the benefit of a deferred sentence with a 1-year probation, no early release from probation.
Yes, Your Honor.
Do you understand that by pleading guilty, you will be placed on probation for 1 year, and so long as you follow all the conditions of probation, there won't be a public record, but and typically I wouldn't give you additional jail time. On the flip side, if you violate your probation, I may revoke your probation and you could be sentenced to up to 93 days in jail. Do you understand all that?
Yes, Your Honor.
Has anything else been promised to you, or have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, Your Honor.
Has Ms. Claxton answered all your questions to your satisfaction?
Yes, Your Honor. Yes, Your Honor.
I need to go over your trial rights with you and make sure you understand those. So please, oh, wait a minute. There is an advice of rights in the file. Okay, so do you recall signing an advice of rights form on May 10th that explained all your trial rights to you, including the right to a jury trial?
No, I do not remember that.
Okay, then we need to go through those. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt, and you have the right to a jury trial to make that determination. Do you understand those rights?
Yes.
You also have the right to have the witnesses against you appear at trial, to cross-examine those witnesses, and to present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand that?
Yes.
In addition, you have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way. Do you understand that?
Yes.
Finally, by pleading guilty, you have the right to appeal that you would have if you went to trial. And any appeal in this case would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear your case. Do you understand that?
Yes.
Knowing all those rights, do you wish to waive them all in order to plead guilty as discussed earlier?
Yes, Your Honor.
All right, then. So turning to the complaint, it says on May 10th, you were at a location, 3911 Brook Drive in Garfield Township in Grand Traverse County, and you were with Amber Marie Sargent. Is that true?
Yes, Your Honor.
And is it also true that you made an assault on Ms. Sargent?
Yes, Your Honor.
What did you do?
I threw a dresser drawer at her leg.
Did you hit her?
Yeah, it hit her on her leg.
Okay, and I assume you weren't just playing around. Sounds like that would be kind of scary and hurtful. Is that correct?
Yes, Your Honor.
And you weren't acting in self-defense, were you?
No, Your Honor.
How do you know Amber Sargent?
She's my mother.
Okay, so she is a resident or a former resident of your household, right?
Yes, Your Honor.
Okay. Then to the charge of domestic violence, how do you plead?
Guilty.
All right, I will accept your plea. I find it's voluntary, accurate, and understanding. We're going to set this for sentencing at a later date. Ms. Odom, you want to work with Ms. Claxton on that?
Sure. Does Thursday, July 22nd at 9:45 work?
Yes, it does.
Right, prior to that time, I do need to get a pre-sentence investigation report. So Ms. Miller, can you please jot down this phone number and call between 1 and 4 o'clock this afternoon?
Can you hold on? I need to get a pen.
Take your time. Let me know when you're ready.
Okay, thank you. What is the number?
Okay, it's 231-922-6899.
231-922.
6899.
6899. And I have to call them between
1 and 4 today.
Okay.
Okay, we're all set for today then, unless there's anything else for you, Ms. Claxton or Ms. Wilson.
No, thank you, Your Honor.
All right, thank you.
And no assessment, right?
No assessment.
Thanks.
Thank you, Your Honor.
Thank you. All right, let's see, Ashley Middow is present with her attorney, Mr. Travis, and this is the date for a probation violation hearing in file 2044883SM. So, Mr. Travis, what does your client wish to do?
Your Honor, it is my understanding that Mrs. Middaugh would acknowledge and admit to the violation that she violated the community service work agreement. And at the time of the report, she was in arrears on the payment. I think that's been corrected, but at the time, she was behind on her payment plan also.
Okay, so is that correct, Ms. Middow? You want to admit to those violations?
Yes.
And you understand the worst that could happen is I could revoke your probation and you could be sentenced to up to 93 days in jail.
Yes.
Okay, and nobody's promised you anything or threatened, forced, or coerced you in any way to get you to plead guilty to the violation, correct?
No.
All right, so is it true you were placed on probation on February 17th, 2021 for retail fraud third degree, and as a condition of that, you were to pay all your fines and costs on a payment agreement, and you failed to, well, you were $100 in arrears on May 25th. Is that correct?
Yes.
Is it also true you were ordered to do community service work and you violated the rules of the community service work agreement? Is that true?
Yes.
All right. What did you do specifically to violate the community service work agreement?
I only got, I believe it was 4 hours done.
Okay. Out of, what was it, 3 days of community service work?
Yeah, 24 hours, I think.
Okay. All right, then, to those violations, how do you plead?
Guilty.
Okay, I will accept the plea, find it's voluntary and accurate and understanding. So, Mr. Travis, what would you like to say on behalf of your client?
Thank you, Your Honor. Your Honor, Ms. Middaugh is a stay-at-home mother primarily. I believe she has two children currently, and she is in the past couple, more than that. But she's also, I think, about 10 weeks pregnant, and she's had a lot of morning sickness, has been trying to get help from the doctor with that, but apparently it's been quite difficult. Also, her husband is employed. They do not have their car registered and insured. He gets rides to work from a friend, but she struggled with transportation during the course of this. And speaking with her about this, she is definitely willing to do the community service. She has just had some issues making it happen. And looking through the report, there was a number of times when she just did not do what she was supposed to do. But there were some times when she actually had a doctor's note. But so she understands that she should have done this, but she's had some, I think, real trouble complying with it. She is willing to do the community service, Your Honor. I think her main concern is that she is the primary caretaker of her children. And if she were to have to go to jail, that would mean her husband would have to stay with the children and wouldn't be able to go to work. And that may even cause him to lose his job. Hopefully not, but don't know. So that's her main concern. The recommendation does call for just revoking probation. If that is what the court would like to do, we understand that, but she definitely wanted the court to understand that she will and is willing to do the community service. Thank you, Your Honor.
All right, Ms. Middaugh, is there anything you want to say?
I mean, not really. I know I didn't do the community service work. I have with the fines, I paid the 100, and then I believe it was 200 on that, and I plan on paying that off within the next week or two. It's just been really hard, with the community service work. I just found out, I'm pregnant. I have 3 kids, 3 girls already. I stay home, I'm a stay-at-home mom. I understand, I should have done the community service work, and I did try, very hard to do it. And I do understand, I didn't get it done in the time they told me to.
All right, anything you want to add, Ms. Morton?
I guess just listening to Ms. Middaugh, I'm not quite sure how she's going to be able to get her community service work done. She also has a retail fraud that she hasn't finished. And she has just over a month left of probation. I know she hasn't reported for June. There's been some email back and forth between her and I. She explaining she doesn't know when her report day is. She's had so many different probation officers. So I guess I'm a little concerned is all.
Okay, well, I think Ms. Morton's concerns are valid. The defendant has had since February 17th to complete a retail fraud class that can be done online. To complete 3 days of community service work, she's done 4 hours. And so those were pretty light conditions. And, this is your task to get this done. It's not Ms. Morton's job to be a babysitter for you. You were given an opportunity to do community service work, and you haven't done it. There's no good excuse for why you couldn't get this done in the last 5.5 months. Lots of people have kids. I got 3 of them. I know how much time they take, but I don't understand not being able to get 3 days of community service work done in the time requested. Hang on.
Whenever there.
It appears there's a prior retail fraud from March 11th, 2020. That's the conviction date. Am I right about that, Ms. Morton?
I don't believe it was 2020. I think it was 2019. It was at Meyer, I believe.
Okay, so this would make it this was your second retail fraud offense.
Yes.
Based on that, I think jail time is appropriate. You've had the time to do the community service work.
There's
and,
no way
so
I can get an extension to do like 30 days. I mean, if I go to jail, I'm going to lose everything, honestly.
Wait, how many times do we have to harp on you to get this done? No, we're done. We're finished. So it'll be 3 days in jail instead, and you need to report to the jail by Friday at 5 p.m. That's it. All right, let's see. Next case, Mr. Graff, are you there?
Yes, good morning, Your Honor.
Good morning. All right, and is Heather Bloom present?
She is, Your Honor.
This is the date for a probation violation hearing. Mr. Graff, have you spoken to Ms. Bloom, and what does she wish to do today?
We have, Your Honor. We've gone through the original violations, the added violations, and then the added violations since June 10th. She'd be admitted responsibility to all of those violations.
Okay, so is that correct, Ms. Bloom? You want to admit to the violations?
Yes, sir.
And has anyone used any force, threats, coercion in any way to get you to admit to these violations?
No, sir.
And no one's promised you anything about what would happen if you admitted to the violations? Did you hear that?
Yes, I said
has
no,
anyone?
sir.
No. Okay. You might need to lean into your microphone a little bit so I can hear you. Okay.
Okay.
All right. You understand that by pleading guilty to a probation violation, the worst that could happen is your deferral could be revoked, your probation could be revoked, and you could get up to 30 days in jail.
Yes, sir.
All right, then is it true you were placed on probation April 1st for domestic violence with a deferral and OWI?
Yes, sir. I believe so.
And is it also true that you were ordered to take and pass preliminary breath tests to verify that you were not consuming alcohol?
Yes, sir.
And is it also true you were supposed to complete without any unexcused absences, the AWARE program.
Yes, sir.
And let's see, you were also supposed to report to your probation officer on a regular basis, correct?
Yes, sir.
And also you were supposed to take urine screen. Is that true?
Yes, sir.
All right. The violations listed in the report say that you missed your May 28th PBT as well as your May 29th through June 9th PBTs. Is that true?
Yes.
You also missed your June 10th through June 14th PBTs, correct?
Yes, sir.
And you missed a June 15th urinalysis test, correct?
Yes.
And you failed to appear for the AWARE program on May 4th, May 24th, and June 23rd. Is that true?
Yes, sir.
Finally, you failed to report to your probation officer for your regular monthly visit on June 2nd. True?
Yes, sir.
All right, then. I will. Oh, then to those violations, how do you plead? How do you plead? I'm sorry, I didn't hear anything.
Sorry. No.
Okay. I'll accept the plea and find it's voluntary, accurate, and understanding. So, Mr. Graff, what would you like to say on behalf of Ms. Bloom?
Thank you, Your Honor. Your Honor, it's my understanding at the original arraignment, Ms. Bloom wanted to accept responsibility for these. I think she understands that she did violate probation quite extensively. To her credit, I think we take a look. She's only been on probation for just under 3 months. She paid off all the fines and costs already. In fact, although she did miss some AWARE programs, as I look at the information, she's actually overpaid. She made payments in the midst of missing some of these appointments. And when I informed her that she had a balance that was owing to her, she indicated that she would have gone back and like to attend that class. I think we take a look at the information here. She's indicated that she goes to AA still and that she likes this. I think in talking to Ms. Bloom, she indicated she met 2 friends there. She doesn't have a whole lot of friends. And so it has been beneficial. She's proud of her sobriety. I understand the court questions probably the sobriety, given the fact there's so many missed tests here. But I think we take a look back at the original information at the time of sentencing. Here's a young woman who was introduced to alcohol by her mother at the age of 8. And at the age of 11, her mother was giving her alcohol and cigarettes. She's very candid in her assessment, in which she was drinking up to a 5th on a daily basis. And then ultimately it went to about a 1/2 gallon. And so I see Ms. Bloom today. I've talked to her throughout this. I don't think that, if she was back to drinking a 5th of alcohol a day, that she'd be appearing or doing as well as she is as she appeared before the court today. She understands there's consequences for her actions. Things have been really tough for her, as the court made note from the original sentencing. Back in, I think it was 2015, there was a car accident in which she was hit as a pedestrian, which resulted in a TBI and ultimately her leg being amputated in December of 2020. And so she's dealing with some issues for that. I think that if you take a look at the notes from the AWARE program when she did attend, she did have some strengths and some progress that were noted. Just unfortunately, her inconsistent attendance and being involved in that program prohibited her from obviously making further progress. And speaking of Ms. Bloom, she informed me that she did a CHS intake on June 28th. She did individual therapy on July 8th and group therapy on July 13th. All that said, she understands the recommendations. She does not believe, and I think Ms. Morton also agrees, that it doesn't sound like probation is working for her, and the only alternative is a jail sentence. She understands that if she goes to jail because of her leg amputation and the prosthetic leg, she'd probably be put in isolation. So it'd be a little bit different than a typical jail sentence, being there all by herself. Given some of her health issues, given some of her issues and her progress, Your Honor, we'd ask her to consider a shorter term of incarceration than the 30 days. But we would agree that it's about time to end probation. I think it is a significant penalty to have the domestic violence conviction on her record. I wish that it would have worked. I think we take a look back at her prior probation back in 2018. She was successful. And so when she says that she wasn't aware to keep going with the terms, I understand how the court may question that, but she did not violate previously to be aware of what's happening. but I think she was candid in not denying that she missed all of these things. I think in the emails between herself and Ms. Morton, she indicated that when we talked, I told her to try to get back on the horse, and she did follow up with Catholic Human Services, as far as I understand. Unfortunately, she didn't have the funds to get the machine turned back on. When talking to her originally, when she did miss a couple of the tests, she indicated to me the first couple tests she missed, she was able to make it into New Directions by 9 a.m. A couple thereafter, she was able to get in and do a PM test, which unfortunately doesn't mean a whole lot to the court, but she was trying, and then kind of just ultimately just stopped. And so unfortunately, I think we've come to the end of the road. We asked the court to follow the recommendations in the spirit of revoking the probation as well as a deferral, but consider a lesser term of incarceration given some of the issues that she presents to the court health-wise and otherwise.
All right, Mr. Graff, I just want to be clear. You're saying that the Scram machine was shut off because she wasn't able to afford the payments.
That's what I was informed, Your Honor. When I talked to her, we talked about, because when we first talked to her, there's the question, I think it comes up in the information here, of as soon as she violated, whether or not she should continue. When I talked to Ms. Bloom, and I think it's noted in the email to Ms. Morton, that she was told to continue with probation terms. Her concern to me was, I don't have the money. How do I get it turned back on? I don't drive. And so how do I make it to the facility? And so unfortunately, she did not start testing again. But as I understand it, there's a high enough balance that she couldn't afford to get the machine turned back on. And so that is a reason for not testing.
All right. Thank you, Mr. Graff. Let's see. Anything you'd like to add, Ms. Bloom?
No, Your Honor. I think he pretty much got it. I mean, other than, financially, I just, when I seen you, when you first put me on probation, someone's back, I let you know that if I was to ever come across any problems, I'd let Ms. Morton know and whatnot. And when I missed, I emailed her either right before or, before I went and tested. I emailed her and I missed, I'm so sorry, and it just got to where I had a new sleep aid medication circle. That's why I wasn't waking up with the alarm. And then now financially I just can't. And I would just take responsibility and that's about it, Your Honor.
All right. Thank you, Ms. Bloom. Anything you'd like to add, Ms. Morton?
No, Your Honor.
All right. Defendant was placed on probation on April 1st of this year for both domestic violence with a deferral and OWI. And the defendant was ultimately sentenced to probation, and her prior record includes disorderly conduct. Well, that was actually dismissed in 2010, a disorderly conduct in 2016, and 2018 assault and battery, where the probation was successful. The facts are that the defendant was intoxicated. She was at the Goodwill Inn. She had a 0.20 blood alcohol concentration. She explained to the officer at the time that she has a very high tolerance for alcohol. And she said her foot came off the brake and the car rolled forward into a pole and was leaking fluids. The car was leaking fluids after the crash. She got into an argument with her fiance's son and struck him with a closed fist. And so those are the facts. The hope here was to help address what appears to be a serious substance use disorder. And unfortunately, that doesn't seem to be something that makes sense here, given the defendant's financial condition. She's going through the court for disability, has no income, and it seems to me there should be some sort of way to provide free testing for someone in Ms. Bloom's situation, but we don't have that available apparently. So anyway, so then the question is what to do on this third and fourth conviction for both domestic violence and OWI. I do think there's a serious public safety issue with the intoxication. Ms. Bloom says she doesn't drive, which is probably a good idea, but you know, she was driving back when this happened in September of 2020. I don't think it makes sense to try to continue the probation under these circumstances. So I will revoke the deferral and the probation. The recommendation is for 30 additional days in jail. I think that, let's see. The total jail time to this point is 1 day. I think given the offense and the prior record, the jail time recommended is appropriate. So it's going to be 30 additional days in jail. You're to turn yourself into the Grand Traverse County Jail by 4 p.m. this afternoon. And that's it.
I don't drive. The only person I do have that I'm able to get a ride from works anywhere between 6, it gets off of work anywhere between 6 and 8. But I was wondering, if at all possible, could you possibly give me a day or two, or possibly even a Monday, because I'm in the midst of moving.
I will give you until, I'll give you an extra day to turn yourself in. So it'll be 4 p.m. Friday, that's tomorrow. And that should give you time to work all those details out.
Okay.
All right, that's it for today then. Yeah.
Yeah.
Thank you, Your Honor.
Yeah. Okay, let's go on to the preliminary examinations then. And who do we have from the prosecutor's office this morning? Ms. Roberts.
Morning, Your Honor.
So, Ms. Roberts, which case would you like to take up first?
I think they're all going to be pretty quick. I guess let's start with Mr. Trudeau. I think that's a waiver, if I'm understanding that one correctly.
Okay, so this is filed 215345, People versus Christopher Trudeau. Mr. Warden is here on the defendant's behalf. Ms. Roberts for the people. And this is the date for a preliminary examination. Mr. Warden, what does your client wish to do?
Yes, Your Honor, this will be a waiver of the preliminary examination today.
All right, you've explained the purposes of today's hearing to your client, and that's what he wants to do as well.
I have, and yes, that is, Your Honor.
Ms. Roberts, are you agreeable to waiver of the preliminary examination?
Yes, Your Honor.
And Mr. Trudeau,
Yes, Your Honor.
Is that what you wish to do also?
Yes, Your Honor.
Okay. Do you have the?
I'm getting that.
Okay. So the examination has been waived. The defendant is bound over on the charges in the complaint to appear next on July 16th. That's at 1 p.m. for the circuit court pretrial. Is there anything else we need to take up before the circuit court arraignment, Mr. Warden?
No, Your Honor. Thank you.
All right, so go ahead, Mr. Warden.
Yes, Your Honor, we would like to proceed to circuit court arraignment. Mr. Trudeau is aware of the charge pending against him. The charge is pending against him. The maximum penalty for each would ask the court to waive a formal rating of the felony information and enter not guilty pleas at this time.
All right, I will enter not guilty pleas on the defendant's behalf. The defendant is, bond is continued. Is there anything else before we let Mr. Trudeau go for today?
No, Your Honor, I didn't hear the pretrial date. I know you said it, but I didn't catch it.
The 16th of July.
Thank you very much.
All right, we're all set then, Mr. Trudeau. Feel free to sign off.
Yes, sir. Thank you.
Okay. Yep. All right,
Yeah.
Ms. Roberts.
Your Honor, if I may.
Oh, yeah, go ahead, Mr. Warden.
Miss Counselor is in the jail. I'm wondering if I can have a breakout room with her. And maybe you can handle it differently.
Okay, I think I had to mute the jail there. So, Ms. Counselor, if you could see if you can get the clicker there to take you off mute or ask one of the corrections staff. Oh, there's an officer. Thank you, officer.
You're welcome.
All right, so. Okay. So, Ms. Roberts.
Thank you, Your Honor. Next, we have Mr. Kelly. I don't believe that we have any information for that he's going to be here. I do believe he's in bench warrant status.
Correct, Your
Okay,
Honor.
so, and you haven't had any contact with him then, Ms. Mistley?
I have not, Your Honor. After our prelim in the other matter last week, I emailed him again and still have not heard from him. So it's been 2 or 3 weeks since I've had any contact with him.
All right, well, it's now 11:16 a.m. The case was scheduled for 11 a.m. The defendant having failed to appear, I'm gonna revoke bond.
There's already a bench warrant on this case, Judge.
There is a bench warrant, okay.
Correct.
And is bond
Canceled already.
canceled already, okay. All right, anything else we need to take up on that case, Mr. Lee?
No, thank you.
All right, or Ms.
No, Your Honor, thank you.
All right, thank you. Okay, Ms. Roberts.
Next would be Mr. Weiss.
Your Honor, Cynthia
right.
Conlon on behalf of Mr. Weiss. I was just appointed to this case on Tuesday, so Mr. Atwood and I signed and I filed a stipulation to adjourn the preliminary examination today. And that has been filed, but I didn't see where you'd signed it yet, so I thought I better appear. My client's at work and I had told him not to appear because I believed you would adjourn the hearing.
Okay, you must have just submitted that because my inbox was clear yesterday.
Yeah, it got filed yesterday, Judge.
Okay, all right. What was the reason for the adjournment? Because of the recent appointment?
I got appointed Tuesday. The probable cause conference was supposed to be Monday. I got appointed Tuesday. I have no discovery at all yet. I have a weekend complaint and that's all I've got.
All right. Do you have permission from your client to waive the preliminary examination?
I do, and as is indicated on the written stipulation, he waives the 21-day rule.
Oh, that was in the stip too. Okay.
Yes.
Great.
Yes.
All right. So then we'll go ahead and adjourn this out. Miss Odom, you want to pick a date?
Sure, how long would we like?
Well, I got
2 weeks or 3 weeks.
nothing yet, so 3 weeks would be best because I'm on vacation next week. So.
Ms. Conlon, we don't have an appearance for you yet, so that might be why you don't have anything.
I filed an appearance. Okay.
I'll check with Stacy.
I mean, I assume I don't have anything because I got appointed Tuesday, filed my appearance that day, and Ms. Bramer was out of the office yesterday. So I think that's why I don't have it yet.
So your appearance could be in, it's just not in my file.
Yeah, exactly.
I will double
So-
check with her though, just to confirm.
Okay, thanks.
So I'm sorry, how long do you need for the prelim?
I was gonna request 3 weeks if we can. I'm not
Okay.
available the 20th, but other than that week, if you're looking at the week of the 19th.
How about the 22nd?
I'm MIDC that day. I mean, we
Okay,
could do it
let's
in the
not do that.
afternoon if you wanted to. I think it's gonna be a waiver. In fact, I'm almost certain it's gonna be a waiver.
What about the 23rd?
That's fine.
Okay, at 11.
That's fine. Thank you very much.
Thank you. Thank you.
All right, thank you, Ms. Condon.
Thank you.
What happened to Patrick Reed Jr.? Was that taken off the docket for some reason?
I don't have them on my docket.
Okay, well, I'll assume that was adjourned or something.
Yeah. Did you bring in your older docket? Or you see
Yeah,
them
I've
here?
got the old one, I
Maybe
guess.
so. All right. Let me think here.
All right, this is People versus Summer Counselor. File 215387FY. And Ms. Roberts is here on behalf of the people and Mr. Warden for the defense. So, Mr. Warden, what does your client wish to do about the preliminary examination today?
Your Honor, this is actually a sobriety court plea, or excuse me, a drug court plea. The offer would be to plead to possession of methamphetamine with drug court consideration. If she's successful, it would be reduced to use of methamphetamine after the normal course, which I believe is still 1 year.
All right, is that a correct statement of the plea agreement, Ms. Roberts?
Yes, Your Honor, sorry.
Okay. All right, so let's see. Ms. Counselor, is that also your understanding of the plea agreement? The charges against you would be reduced to a single count of possession of methamphetamine?
Yes,
Is that
sir.
correct? And you'd be considered for the drug court, and if you're successful after the first year, that would be reduced to a use of methamphetamine. You understand?
Yes.
Okay. Do you also understand that if you are not successful on probation, the conviction for possession of methamphetamine may enter, and that carries a penalty of up to 10 years in prison? You understand that?
Yes, sir.
Okay. And you'd be sentenced up in circuit court for that. Do you understand?
Yes.
All right. At this point, I'm going to swear you in. You want to raise your right hand? Do you swear or affirm that the statements that you're about to give will be the truth?
Yes, I do.
All right. Ms. Roberts, are the people aware of any other inducements or offers or promises that have been made to get the defendant to plead guilty?
No, Your Honor.
Mr. Warden?
No, Your Honor.
And Ms. Roberts, are you aware of any force, threats, or coercion used to get the defendant to plead guilty?
No.
Mr. Warden?
No, Your Honor.
Okay, and Ms. Counselor, is that true? You haven't been promised anything else that hasn't been disclosed on the record today to get you to plead guilty, and you haven't been threatened, forced, or coerced in any way to get you to plead guilty. Is that true?
Correct, yes.
So it's your own free will to plead guilty today. Is that correct?
Yes.
All right. I need to go over your trial rights with you, make sure you understand those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt by the prosecutor. And you have the right to a jury trial to make that determination. Do you understand those rights?
Yes, I do.
You also have the right to have the witnesses against you appear in trial, to cross-examine those witnesses and present your own evidence and witnesses. And the court would order those witnesses to appear if need be. Do you understand that?
Yes, I do.
And Ms. Odom's pointing out I need to have a prelim waiver before I complete the plea process. So we'll get to that, but we'll finish the rights first. So do you understand that you also have the right to testify at a trial, or if you choose to remain silent, and that silence could not be used against you in any way?
Yes.
Finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial, and any appeal would be by leave, not by right, meaning it'd be up to the appeals court whether to even hear any appeal of your conviction or sentence. Do you understand that?
Yes, I do.
Right, and knowing all of those trial rights that you'll be giving up by pleading guilty, is that what you want to do?
Yes.
Okay, let's go back to the preliminary examination. So, Mr. Warden, I assume that you've advised your client to waive the preliminary examination?
Yes, we have discussed the nature and purpose of a preliminary examination. We're prepared to go forward with a waiver to effectuate the drug court plea.
Okay, and that's what you want to do as well, Ms. Roberts?
That's correct, Your Honor.
Okay, and Ms. Counselor, that's what you wish to do as well, waive your right to a preliminary examination?
Yes.
All right, so the defendant is bound over to the circuit court on the charges in the complaint, at least for now. All right, has Mr. Warden answered all of your questions to your satisfaction?
Yes, he has.
All right, so turning to the complaint at this time. All right, so the probable cause statement says that on June 11th, you were transported to the jail on a probation detainer, and that would be the Grand Traverse County Jail. Is that correct?
Correct.
Okay, and during that transport, you admitted that you had 2 baggies of meth in your crotch area of your clothes. Is that right?
Correct.
And you put them there because you were afraid of your probation officer and CPS and that they might discover those.
Yes.
All right. Was there a test of the baggies for meth, Mr. Warden or Ms. Roberts?
There was a true narc test, Your Honor.
Okay, and that was positive for meth, no doubt.
Yes.
Okay, and Ms. Counselor, you're not disputing that was meth. You've had experience with meth before, and you knew it looked and well, it looked like meth, and you were confident it was meth, right?
Yes.
All right. So then to the charge of possession of methamphetamine, how do you plead?
Guilty.
All right, I will accept your plea. It's obvious that it's voluntary, accurate, and understanding. So what's going to happen next is we'll set this for sentencing at our next drug court. Well, what date do you have, Miss
Let me
Odom?
look.
We got to have time to review the case at drug
Right.
team meeting.
So I'm thinking the 20th.
Okay,
July.
how's that work, Mr. Warden?
That
July
works.
20th?
What time?
All right. Probably 10.
Mhm.
Okay, 10 o'clock after our regular drug court hearings. And what's going to happen then is we're going to review your case, the drug court team. And if we feel that you're an appropriate candidate for the program, then you'll be sentenced to the drug court program. If for some reason that doesn't happen, I would allow you to consider withdrawing your plea if that's what you want to do. And I need to get a substance use assessment. Someone from our probation office will contact you about that. And also, let's see, substance use assessment. And we'll be back for sentencing on the 20th. Now, I just realized we also skipped over the circuit court arraignment. Mr. Warden, for the record only, did you advise Ms. Counselor of the nature of the charges against her and maximum penalties prior to the plea?
I did, Your Honor, and just for the record, again, out of turn, but we would certainly waive reading of the felony information and ask the court to enter not guilty pleas for that moment, and then obviously follow it up with the guilty plea to count one.
Okay, thank you. All right, are there any other issues we need to take up today?
I don't believe so.
No, Your Honor.
Okay. All right, is Ms. Counselor still being held on that circuit court detainer?
She is, Your Honor. This was a new development. The drug court plea came about, or at least the drug court offer came about on Tuesday. And so I've got some work to do with DOC. I may be raising that with this court at some point, but she's earning time on the 30 days for drug court anyway. So I think right now she's in the appropriate spot, and we may have an update for you before the 20th.
Okay, well, I don't know what the circuit court might do, Ms. Counselor, but rule of thumb is I would probably release you on the sentencing date to an inpatient treatment or intensive outpatient treatment program, and then a sober living home after that, okay? But it would be unusual for me to, even if the circuit court were to let you go tomorrow, just let you out on your own without some kind of plan in place first. So that's kind of what you can expect from here. And we're all set unless there's anything else, Mr. Warden.
No, Your Honor. Thank you.
Thank you.
Roberts.
Nothing, Your Honor.
All right,
Thank you.
All right.
Push the button on the right.